Welcome everyone, just near and far and everyone in between. I love it. I love that we're getting people on now and we'll have people joining us throughout. And this will also be recorded and be able to be posted on the webpage so that you can look at it later too. So that'll be awesome. So welcome everyone. I'm Heidi. I'm your webinar host. I'm also a podcaster. So I'm just grateful to be here and I'm excited to be able to talk to Joan. So are we ready? Are we ready to learn? Are we ready to grow? Are we ready to succeed? Well, then we've got a great person here. Joan, do you want to start out by just telling us a little bit about yourself?
Sure. My name is Joan Andrews, and I am a attorney in Salt Lake City, Utah. I am with the firm of Fabian Van Cott. I've been practicing school law and representing school districts and some charter schools for the better part of about 20 years now. So that's literally the range of everything, although a lot of it is employment law. That's a very significant part of what I do for my clients, is try to navigate the multitude of employment laws that we deal with and really just focus on a preventive approach, try to keep folks out of trouble, and as necessary, we litigate when called for. So that's a little bit about me. It's work that I very much enjoy. My dad was a high school principal, so when I managed to work my way into the practice of education law, it was just a natural fit for me, and have such great appreciation for educators and what they do on a day-to-day basis, and love to be able to help out. So
I love that. That's super great. And we need people like you. So the educators need you as well. So we're grateful that you're here to talk to us today. And I'm excited to hear you have a little presentation for us.
What we put together was a little bit of a presentation on First Amendment basics.
Yes.
Which was, I thought, a good topic because there is some general big principle uniformity from state to state. So I was hoping it would be relevant for the majority of your audience, who I think is, primarily administrators, but around the country. And also it just continues to be timely with everything that's been going on around the country, regardless of what sides of particular issues folks are on. Employees seem to be engaged in more and more speech in more and more ways, and sometimes conduct too in connection with that speech.
Yes.
So the complexity of the area kind of seems to be getting greater, and I thought would be a helpful refresher.
Yes,
So
we need some tips. We need your advice.
So I have a little bit of a PowerPoint here.
Okay.
And I think if I go into the share screen, you will see my PowerPoint.
Yeah, got it. Good job.
And if I can get it to come over to my other screen, then I can look at the camera at the same time. So hang on just a second. I'll see if I can, oh, not that one.
This is great. I'm excited to hear more about this. So thank you for putting this together.
Just see if I can. Well, okay, we'll just go with that screen. Is everybody, you're seeing that on your?
I can see your screen. Yeah, and I can see you too. So that's awesome.
Excellent. So, all right, what we're going to do is a little bit of a overview of First Amendment law with respect to employee speech in the public school employment context. My standard disclaimer: general informational purposes only, should not be construed as specific legal advice. I am only licensed in the state of Utah, not in any other jurisdictions, and you should always consult with your own legal counsel with respect to specific questions that might arise. So let's dive right in, right? What are we working with? We're working with the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That's a topic for a whole different presentation on religion, or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for redress of grievances. Right? So we're obviously dealing with the prohibiting the free exercise thereof aspect of the First Amendment. And as you know, those of us that remember our social studies or social studies teachers or our college history classes, right? This applies to Congress, right? So what makes it applicable to state and local government employees? We get the 14th Amendment that makes all of the protections applicable to the state, right? So no state shall make or enforce any law which abridges the privileges or immunities of the citizens of the United States. This is how we get to the extension of the First Amendment protections, post-slavery. All right, so a little caveat here. I do know that we have some people tuning in who might work with charter schools or for charter schools, right? So these protections that we're talking about clearly apply to employees of traditional public ed institutions, like school districts. And they're generally political subdivisions of the state, they're public entities, they're regarded as state actors. What about charter schools? Are they state actors? And this is where I would say again, yeah, you need to know the law of the state in which you're operating, because there are cases from around the country that reach different conclusions regarding the extent to which charter schools are state actors. And it very much depends upon each state's statutory structure for the establishment of charter schools. In Utah, charter schools have a heck of a lot of characteristics of other public entities, and they are generally treated much the same as traditional school districts in the state of Utah. But we don't actually have any explicit cases saying, are employees of charter schools entitled to First Amendment protections? And there are some cases out of the Ninth Circuit involving Arizona, involving California, involving Idaho, that seem to be a little bit conflicted about this area. I guess where I kind of come down on it is, for the most part, people that I'm working with, they're not eager to get involved in litigation. They don't want to be that test case necessarily. So regardless of whether your charter school is or isn't considered to be a state actor, I think there's a lot of value to just taking that cautious, risk-averse approach and saying, all right, well, assuming that I am determined to be a state actor and these protections apply, what would the analysis be? So I think it's fairly relevant regardless.
Great.
Right, and just kind of as a reminder, I'm going to be talking primarily about some key Supreme Court cases. And those cases under our federal system are going to be binding across all 50 states and territories. Then some of the nuances tend to get worked out at our lower level courts, our circuit courts of appeal, and our federal district courts. So it's helpful to know what jurisdiction you're in terms of your circuit courts of appeals and being able to look at decisions that come out of those circuits, as well as your federal district court levels, because those cases are generally going to be pretty persuasive in those jurisdictions. Right, so here in Utah, we're in the 10th Circuit Court of Appeals, and I apologize, this appears to be a slightly blurry graphic, but you can see, we cover generally these Rocky Mountain states, But the Ninth Circuit is so big, and that's where I was saying we have quite a few decisions about charter schools out of there. And then our other, 1 through 11 circuits around the rest of the country. So just always helpful to have a good understanding of where you are. All right, so what are we going to be talking about in terms of this overall analysis? We have 4 main United States Supreme Court cases that we primarily deal with that establish the framework for our analysis of employee speech protections. Started in 1968 with Pickering versus Board of Education. And this is where we kind of really first established that public employees don't lose their free speech rights, that they do have First Amendment protections. So this involved a high school teacher, Marvin Pickering. He was terminated from his employment when he wrote a letter to the editor that was critical of his school board. And what the court did in that case was basically to say, no, we think that was a wrongful termination because this was a matter of public concern that he was commenting about. And just because he's a public employee doesn't mean that he can't still comment on issues of public concern. And they kind of first reached a balancing test and said, we've got to consider the balance between the interests of the teacher as a citizen in commenting upon those matters and the interests of the state as an employer in promoting an efficient workforce that is not overly disrupted by employee speech. And that then, several years later, 15 years later, was followed by Connick versus Myers. And so what we ended up with as a result of those 2 cases is what we call the Pickering-Connick balancing test. So interesting fact, Connick, the case there actually involved, it was filed by this woman named Sheila Myers. She was an assistant district attorney in New Orleans. She had objected to being transferred to another section of her office. And after being notified that she was going to be transferred, she distributed a questionnaire to the office staff that raised the issue of whether the district attorney's office was poorly run. And the name of the district attorney, interestingly enough, Harry Connick Sr. So New Orleans, Harry Connick Sr., yes, none other than piano man Harry Connick Jr.'s father, longtime New Orleans district attorney.
Wow.
So that's kind of a fun fact.
Fun fact, but, that's awesome.
So basically, it's taking the position, listen, here, I can't have this employee here who's completely undermining my authority, challenging my ability to run this office. And she said that was a violation of her First Amendment political speech rights. Well, the court disagreed, and it was a split decision. It was a 5-4 decision. They held the dismissal to be constitutional, and they said, hey, you're not actually speaking about matters of public concern. Your issue is primarily focused on internal office workings. And overall, looking at this balancing test, what you've done hinders the efficient operation of the district attorney's office by questioning the boss's authority. So the court found that there were legitimate reasons to fire her. As I said, it's not necessarily wasn't an uncontroversial decision given that it was 5-4. Our next two cases kind of go to the issue of, well, is the speech a matter of public concern or not? So Garcetti versus Sabalos in 2006, this involved another attorney's office. I don't know what district attorneys and folks are doing to hire such problematic people, but this was a prosecutor who alleged that he had been retaliated against because he criticized the handling of a search warrant affidavit. He believed that there were untruthful statements made by a sheriff's deputy, and he said that he had been transferred to a less desirable position and stuck in a crummy basement corner closet. I'm just kidding there, but given a less desirable office because he had written a memo that was critical of his boss and had delivered some public speeches that were critical of the office. So what happened in that case was there was an initial finding from a district court that he had no First Amendment claim for speech delivered in the memo because it was part of his job duties, right? And ultimately, the Supreme Court ended up agreeing. They said when public employees make statements pursuant to their official duties, they are not speaking as citizens for First Amendment purposes, and the Constitution does not insulate their communications from employer discipline. So we end up with this analytical structure where we're saying, okay, is the speech something that is part of their job duties, or is it totally separate from their job duties? And when we look at, it becomes important thinking about teaching, right? Because we are essentially paying teachers to teach, and we're controlling the speech that they give in the classroom through curriculum, saying you've got to stick to the curriculum, right? And you're not authorized to go too far afield. And if you're making speech as part of your job duties, that is not protected by the First Amendment. And that was sort of elaborated on a little bit with Lane versus Franks. So very similar issues in Lane versus Franks that have left us with ultimately this balancing test, right? So we've got to decide, is it public speech versus private speech or employee speech? Is it a matter of public concern, right? If they're speaking on a matter of public concern, then we got to balance, does it disrupt the workplace? Does it cause disharmony among coworkers? Does it cause a lack of confidence or loyalty amongst coworkers? Does it impair the operations of the school district or charter school or other public employer, right? And that's where we have to be a little bit careful, I think, as employers, to not jump the gun and just assume somebody said something critical and therefore it's disruptive, right? There can often be desire, to address the issue before there's actually been any evidence that it has disrupted the workplace. But overall, if that test tips in favor of the district, right, they say you can regulate the speech. And I think it's important to note, here in Utah, we have some guidance that says, with respect to the public interest, public concern, and whether it's employee speech, school administrators are generally deemed to be mouthpieces of the school. And so their speech is going to often have less protection, because if they do speak out, it is going to be considered to have that detrimental effect on the overall operations of a district or charter school. Okay, so, we kind of look at this in terms of saying, okay, the kinds of things that are not protected. If it's got to truly be a matter of public concern, not just a personal gripe that affects only that person or is strictly personal to that individual, right? If it's just a personal gripe, then it's not going to have the same degree of protection that a matter of true public interest might have. Talking about a school board policy, or, but if it's, well, my principal called me into the office and disciplined me for being late, that's kind of a personal gripe. It doesn't go to the overarching issue of what is a policy with respect to COVID, right? What are my rights to speak out about matters of public concern as it relates to overall school safety and whether or not we should be going back to work, right? But, so public concern, big picture, affecting multiple employees, personal gripes, this person made this decision that affects me. So that's things to keep in mind. All right, so disruptive speech is not going to be covered, right? If it impairs the operations of the school, that's going to be a problem. Official duty speech, also not covered. And this is just kind of another interesting piece, and I thought I'd bring it up because at least in Utah, and again, going to the issue of state laws, right, we have professional standards that say when it comes to potentially disciplining somebody, right, we're not allowed as professional educators, whether school teacher or administrator, whoever it might be, to interfere with or discourage a student or colleague's legitimate exercise of constitutional, legal, or civil rights. So say, for example, an educator on their own time went to a protest and it was a lawful protest. They weren't arrested. They engaged in no conduct that was problematic. They just went and they held up a sign that expressed their support for a particular cause. Somebody else in the community says, I have a problem with the fact that this teacher was photographed at this protest holding this sign, right? It could potentially, at least in Utah, if an educator were disciplined for that conduct, that could be unprofessional conduct on the person, on the part of the person who did the disciplining, right? Because they're interfering with a legitimate exercise of constitutional rights with respect to their First Amendment speech.
Interesting. I'm glad you brought that up. We did have one of the questions that was asked about if students have the right to free speech in school as well.
Yeah, I mean, yes. So certainly in the traditional public K through 12 school district context, absolutely. That is a whole another line of case law dealing with First Amendment speech going back, to the Tinker case, 1968, Vietnam black armbands, and protected expression, and a lot of nuance in that as well. One thing that is tends to be consistent between the employee and student line of cases has to do with the actual disruption standard. And so generally speaking, if student speech causes an actual disruption in the school is going to have a bit more latitude to deal with that speech. But again, I think sometimes the tendency is to anticipate that something will cause disruption rather than relying on evidence of actual disruption. And that's where we can sometimes get into trouble.
Right.
So wanted to just talk, and gosh, we are running out of time. So what I'm going to do is just I've got some fun slides that I think are just kind of good for people to kind of see the,
Okay, there was one other question too while you're getting those slides.
yeah.
It was, how should my school consider First Amendment protected speech in our employee handbook?
Yeah, so again, I would say for charter schools, you probably want to talk to your local council or charter school association with respect to what exactly the parameters are, but a general statement of recognition of people's First Amendment rights is fine. I would generally not get very specific about trying to lay out all of the what ifs and what is protected, what isn't protected.
Okay.
Because I think that it's too difficult to do that. But an acknowledgement of people's rights to engage in speech, particularly outside of the workplace on matters of public concern, would not be inappropriate.
Okay, that's great. Thank you.
So yeah, just some slides. These are actually ones that I put together well before the summer. These were from 2017 that I pulled some of these slides, right? But
okay.
teachers protesting outside of school in support of Black Lives Matter. A substitute teacher, been substituting forever, right? But he's wearing his Black Lives Matter pin in the classroom. And that's, I think as we look at these, the first one was outside of class. I think schools are going to have much less latitude to control that speech. Inside of class, to the extent, and this is a controversial issue, but I think some would assert that Black Lives Matter is a political statement. Sometimes there are state laws that also go to the issue of employee speech rights with respect to political speech. This is a car in a school parking lot, right? We love our Latin students. Social media postings regarding Day Without Immigrants. This kind of thing really causes a lot of disruption when you talk about people of certain ethnicities or racial or ethnic groups being lazy or getting drunk, right? I mean, that's going to impair their ability to speak in the classroom, right? Yeah, this teacher resigned, which seems like a good outcome.
Wow. Yeah.
And I had a little video in here. This was an anti-Trump teacher who was shooting this video of former President Trump with a water pistol. She also resigned. Again, good outcome, right? Classroom speech, you're going to have a lot more ability to control that. So yeah, I think I know we were scheduled to go until 12 o'clock and we're right about there. I'm happy to stay on and take any
there's any other
questions or if anybody else wants to put anything in the chat, I'm happy to.
Well, also one quick question, which is, I appreciate this. This has been so informative. I've learned so much today about speech. So thank you for what you've put together. Our sponsor Ready2Teach also helps with like substitutes and temporary teachers. So I'm wondering if there's something for protective speech. Is there anything that we need to help them with or anything that would be informative for them?
Yeah, I mean, I think, the general rule, and there have been issues from time to time with substitutes,
Right.
right?
Yeah.
So, um, in terms of, um, I think it's generally an issue for folks that use your service to ensure that substitutes that are being placed into the classroom have a little bit of an understanding, and that they understand that those substitutes are going to be subjected to whatever the school district policies and procedures are,
Good.
um, and that they should just realize that their continued ability to be a substitute could be impacted by inappropriate speech, whether in the classroom or outside on social media, if it were to rise to the level of some of the things that we've seen here
Yeah.
in
Yeah.
slides.
Good reminder. Yeah. That's great. Thank you. It's a great reminder. And this slide too. Wow. Oh man.
Yeah. So, I mean, I guess my point with some of these slides is to say, listen, this stuff is not unique to any particular political persuasion or viewpoint. People across all sides of the spectrum get pretty heated. Um, our schools are truly a crucible for some of the most controversial issues that we deal with in society. And it's a ongoing balancing act to try to ensure that our professionals, our teachers, our substitutes, everybody is respectful, appreciates the boundaries under which we operate, and yet is also free, outside of the classroom to speak their piece and not unduly constrained just because they're a teacher.
Right. Right. This is so timely. What a good reminder to all of us, and a really good way to keep track of what we do and how we act inside and outside of the classroom. So, this has been so informative and so needed right now. So, thank you. I really appreciate your time with this. We will be posting this webinar on the Ready to Teach website in the next couple of days. So, people can listen to it again to be reminded again of your great advice. So, thank you so much. We appreciate your time.
Absolutely, my pleasure.
Awesome. And I'm going to leave us with this little video. You're welcome to log off as we go, but I just wanted to share this with you really quick um, as a goodbye and appreciation again for Joan for being with us today. So thanks again. Everybody have a great day. Play this now.
We know that running a school is one of the most difficult jobs on the planet. Whether it's onboarding a sub, gathering paperwork from a new one, conducting background checks, training, and so much more. The checklists are endless, and keeping tabs on everything can be absolutely exhausting. That's why we created Ready to Teach, so schools and teachers alike could have a simple software solution to guide them through the platform and paperwork they need with the click of a button. Our sleek and easy to navigate web and mobile apps give clients the ability to recruit and onboard subs while also allowing teachers to enter vacation and request time off, no matter where they are in the world. With our job management platform, educators can request subs, manage pay rates, lesson plans, and more. It's clear that our service gives professionals the ability to focus on what really matters, the kids. So visit our website to learn more and schedule a demo today. Let us help prepare you for tomorrow. Ready to Teach. Absence management from start to finish has now been simplified.
Thanks, everybody. Have a great day. Thanks for joining us.